Chapter 11. Statute of Limitations. Saved by the bell. The teacher has called on you to stand up and recite, but you didn't read the book and have no idea what to say. Your face is getting hotter by the second, your palms are sweating, and you know you're about to face complete and total humiliation. But then the bell rings and class is over. Everyone noisily pushes back their chairs, and the teacher says, "Class dismissed." If you've lived through something like this, you are well aware of what saved by the bell means. Time for punishment has run out, and you are blessedly safe, all thanks to the bell. The statute of limitations is like that. It is the date when a creditor can no longer sue you in a court of law for a debt you owe and then seize the money out of your bank account or paycheck. They can no longer place a lien on your property either. The account could be an old credit card that's gone into collections or a repossessed automobile. When a debt grows too old, according to state law, they can no longer sue you. However, that doesn't mean you don't still owe them money for the goods or services you purchased. The debt is there, so they can send you bills and call asking for payment. The account will show on your credit report as an open bad debt, and that hurts your credit rating more than if it is paid off. So unfortunately, the debt isn't wiped out after the statute of limitations expires, so, if you pay and get it deleted from your report, it will improve your credit score. In cases where they have no legal recourse, they offer very low settlements because getting some money is better than getting nothing at all. Whenever I see a settlement offer that looks too good to be true, such as 70% or more off, my first thought is this past the statute of limitations? If it is, you are in the power position for a low settlement and getting a delete for payment agreement. Personally, I would insist on getting an agreement in writing. Email is fine, that states the creditor will delete the account with the credit bureaus upon receipt of payment, within 30 days is fine. You are under no time pressure with a fear of being sued, so you have the luxury of holding out for what you need. Be sure to keep all agreements, both in a computer file and a printed paper file, because you cannot afford to lose them. In cases where pay for delete is impossible, look at when the account will age off your credit report. If it is soon to disappear, then you might choose to ignore it. On the other hand, if your state's statute of limitations is short and it will remain on your report for years to come, and the open balance is docking your score, then you might choose to pay it after negotiating a low settlement agreement. Or if the circumstance causes you to believe the moral thing to do is to pay it, then negotiate a low settlement, knowing that they are making a profit even after lowering the bill to below half. When does the statute of limitations begin? The date is extremely important. If you assume your debt is past the statute of limitations, but you're looking at the date wrong, then you don't have the bulletproof vest from a lawsuit that you thought. There are federal laws and state laws regarding the statute of limitations. The state law that applies to a particular loan depends on 1. What state is named in the contract and 2. What state you live in, giving first priority to the contract. If you move from one state to another, then the law governing the statute of limitations could change, for better or for worse. In addition, there are different rules and dates for different types of loans. In some states, the statute of limitations begins when a required payment is missed. In other states, it begins when the most recent payment was made, even if that payment was made after it went to collections. Zombie debt. Be aware that making a partial payment or even acknowledging you owe an old debt can restart the time period, even after it's past the statute of limitations. Therefore, you must be hypervigilant during any phone calls with a creditor, and in fact, many people would be wise not to speak with them on the phone at all, but rather, stick to written communication where you are less likely to be tricked into saying something against yourself before you've even realized it. For example, if one of those unscrupulous collectors has purchased old debt for mere pennies on the dollar, they may call and ask you a question like, "Were you unemployed or otherwise in hardship when you first went late on this?" Then you say, "I was in hardship." Boom! You have just acknowledged the debt as yours. Now they can revive it from the graveyard and haunt you for payment and possibly initiate a lawsuit. Thus, the term zombie debt. Let's look at some of statutes of limitations. Student loans and statutes of limitations. If your student loan is federal, there is no statutes of limitations and no time limit for collecting on the debt. What's more, the cosigner is equally liable for the debt and can be sued if you default and they don't pay for you. What's really brutal is that even their Social Security income can be garnished for a federal student loan they generously co-signed for. How wicked is it for them to grab Social Security income from a grandma who co-signed on her grandchild's student loan? Owing the government money is not to be taken lightly. If your student loan is from a private company, then state laws apply. Here is a list of state abbreviations. The number after it is the number of years when the statute of limitations expires. Credit card debt and statutes of limitations. The state that applies to you depends on 1. The state specified in your contract, and or 2. The state you live in, if no other state is in the contract to supersede it. The statutes of limitations for judgments might be different than for an unpaid credit card. IRS tax statutes of limitations. The statute of limitations for state income tax is different from the Internal Revenue Service statute of limitations. The amount of time the U.S. government can pursue collecting on IRS tax liability is 10 years, according to Forbes Advisor. Consult with an attorney in your state about state tax debt and to verify the 10 years on IRS debt. I cannot give legal advice, so this is for your general information. Auto loans and statutes of limitations. Detailed information ahead in the chapter about automobile repos. Warning! Creditors ignoring the statute of limitations law. Just when you're ready to breathe a deep sigh of relief for your debt being past the statute of limitations, the Consumer Finance Protection Bureau issues a warning. Even though filing a lawsuit after the statute of limitations has expired is a violation of the Fair Debt Collection Practices Act, collection companies and creditors might still file a lawsuit against you, and the court may still award a judgment against you. What? How can that be? If you don't show up and raise the statute of limitations as a defense, the judge might award them the win. It is the defendant's responsibility to point out that the statute of limitations has expired. Be prepared to show there has been no activity on the account for the number of years required. Your credit report and/or a statement from your bank on official letterhead stationery might serve as proof. If this seems too complex or intimidating, ask a consumer advocate attorney to accompany you. One of my previous book readers was sued by a collection agency. Her attorney had the charges dropped because the account was past the statutes of limitations. Then the attorney turned around and countersued the collection agency for violating the Fair Debt Collection Practices Act, and the judge awarded her money. Talk about a sweet turn of events. Coming up next. If you have issues with student loans, this next chapter is for you.